First matter on this afternoon's calendar is People versus Gary Wright. It's number 88. Counsel, your appearance.
Thank you, Your Honor. May I begin by asking to reserve 2 minutes, please?
Yes, you may.
Thank you. Good afternoon, Your Honors. May it please the Court, my name is Michael Katzer, and on behalf of my client, Gary Wright, I thank you for the opportunity to bring this matter before you. The issues here go beyond those affecting Gary Wright. They go beyond affecting any one individual. The issues here are about the right of the public to fairness in the criminal justice system.
Counsel, in your 440 application, that was based on an actual conflict of interest due to simultaneous representation, correct?
Yes and no, Judge. It was based upon an actual and inherent conflict of interest.
Stay with me for a second.
Yes, I will.
The 440 practice is fairly clear as set out in the statute, and it is the defendant's burden to make the proper sworn allegations. Do you do that there?
Did we do that there?
Yes.
Yes, I think we did.
Explain to me how you did that.
Excuse me?
Explain how you did that.
Well, we set forth facts that Mr. Long represented the District Attorney Soares in October of 2008 in an election matter. And then Mr. Long was retained by Gary Wright in around January of 2009 without any disclosure by Mr. Long of his conflict of interest. And I submit that the failure to disclose in this case is as serious and pernicious as the conflict itself.
Was the election law matter still going on in 2009, Counsel, when your client engaged Mr. Long?
Was the what matter?
Was the election law matter that you first referenced in 2008, was that still going on?
Judge, I have to answer you in the words of your predecessor court, People versus Schenkel. That information is out of my reach and is out of my client's reach.
Did you ask Attorney Long for an affidavit?
No, Judge, I did not. As a tactical matter, I believe that Mr. Long was in an adversarial position with my client, and while I thought of it, I made a conscious decision not to. Mr. Long was the defendant. That's the whole point. Mr. Long was the district attorney's attorney.
I understand.
What's he going to tell me? What he wants to tell me.
Well, that's you're assuming he's not going to tell you the truth.
I'm assuming he's not going to be helpful. Let me respond by saying this.
My point is, suppose you're wrong. Suppose, as Judge Abdul Salam is asking you, if in fact that retainer or whatever you want to call it was over, that the election law thing was over, election's over, everything's over, and now he has another new client. And he goes forward and apparently represents him with pretty good alacrity, getting a reasonable offer of a plea, and this didn't come up till later.
Judge, I would dispute the fact that he represented Mr. Wright well. I think you know in the record he submitted a motion, an omnibus motion, seeking to dismiss the indictment on the ground of lack of forcible compulsion.
Well, let's take that away from it. I got too far ahead of you. But if the election law thing was over,
yes,
and then a month later he gets retained by now your client, there's no conflict, right?
I disagree with that, Judge, for several reasons. One, there's the failure to disclose. When Gary Wright sought to retain Mr. Long, didn't Mr. Wright have the constitutional right to be advised by Mr. Long, by the way, I represented the district attorney, the guy who's trying to put you in jail, just 2 months ago.
Was Mr. Long's representation of the district attorney in 2008, was that a matter of public record?
I discovered it through an Internet search, and it was either in the Albany Times Union paper or some other blog. And it so happens that when I saw that, it struck a nerve with me because I had been involved in another case involving this conflict. But there's another way I'd like to answer both Judge Piggott and Judge Abdul Salam. In judicial matters, if an attorney is a campaign manager or otherwise has an active role in the campaign of a judge, that attorney cannot appear for the judge for 2 years. 2 years. Now, why should Mr. Long or any other attorney be under less of a rule than Your Honors? Why should Mr. Long be...
Is it the rule? I honestly don't know. If you represent a district attorney, you cannot practice criminal law in that county for 2 years?
No, Judge. I'm saying that the The rule is that if you're a campaign manager, let's say, for a judge, you cannot appear before that judge for 2 years. All I'm saying is...
Mr. Long, the campaign manager for...
No, but he was the attorney for the campaign, which kept him on the ballot. And I don't want to jump too far ahead of myself. Not only was that an important matter, but there's another rule here that the spouse of a district attorney cannot handle a criminal case as representing a defendant. The reason for that is it's recognized that spouses have, interconnected, what's good for one, excuse me?
Financial.
Yeah, financial, right, financial and personal.
That's assuming simultaneously being married, doesn't it? I mean, you seem to be suggesting, and I just want to make sure I understand your argument, that even if, as a matter of fact, Mr. Long's representation of the DA was completely terminated by the time he took on representation of the defendant here, he still had to disclose, or it was ineffective assistance of counsel?
Judge,
is that your position?
Yes, Judge. I think the failure to disclose...
Even if he's no longer representing, how long would he have to disclose for? Let's say he never represented Mr. Soares again. How many defendants and for how long does he have to disclose that prior representation under your position?
Not under mine. A good benchmark would be the opinion of the Bar Association of 2 years. Maybe it could be less. Maybe this Court will set another.
The problem with the 2-year rules, if Soares was the judge in the case, I could understand the 2-year rules. But he's not the judge of the case. He would be an opponent. If you work on this in an issue together, and then the next time you and another attorney are on opposite sides, there's no 2-year rule.
I'm sorry, I didn't quite understand that, Judge. It's my fault.
When the 2-year rule applies to attorneys appearing in front of me if I'm a trial court
Yes.
judge, if they worked on my campaign in front of me because I can make a decision on the case. So if Soares, the DA, was a judge, then the 2-year rule would apply. But he wasn't. He was opposing counsel.
Why should any less of a rule apply when a man's liberty is at stake?
Wait a minute. The judge is making that decision. The attorney, the district attorney is going to advocate for the DA, for the people, and then Long advocates for the defendant. But the 2-year rule, the purpose of that, you see what I'm saying, is that the adjudicator, the trier of fact sometimes, and the person who makes a decision about the law can't have that conflict. But here, Soares isn't in that position.
Judge, I disagree with you because we have to look at the big picture. Mr. Soares was charged by the Third Department with the most serious ethical violations that an attorney could commit. And who did he go to for that? Jim Long. Later, Mr. Soares was going through personal matters, and he went through a divorce. Who did he retain? Jim Long. As we just discussed with you, Judge, if you are in matrimonial situations, spouses can't be on the other end because presumably a spouse is the most important person to the other spouse. In this case, I submit to you that the most important person to David Soares in his life during this time period was not his wife, but was Jim Long.
Well, if that was true, that would help your client, it would seem to me.
No, not necessarily.
Because you're saying to the victim of this attempted rape, you cannot have the district attorney of Albany County representing you. You know why? Because his good friend is representing the defendant. So we're going to have to get somebody else to prosecute on your behalf the person who you are accusing of attempted rape.
But that didn't happen.
Does that make any sense to you at all? I mean, I didn't.
Well, in other cases, once this conflict came out into the public, in every other case where Jim Long represented a criminal defendant, the district attorney applied to county court, and they submitted an affidavit asking for the appointment of a special prosecutor. And what they said was, quote, this is
Were those situations of simultaneous representation?
I don't know. I will never know. The only person who knows is Mr. Soares, presumably Mr. Long. And the other argument I'm making.
Mr. Long.
Yeah, Mr. Long. Now, I hope you can understand as a strategic decision why I did not seek an affidavit from Mr. Long.
Okay, counsel, but you have an assistant district attorney who submitted an affidavit saying that there was no representation at the time that Mr. Long represented your client. And the assistant district attorney represents the district attorney, yes?
Judge, that affirmation was made upon information and belief, worthless under the law. of evidence. Personal knowledge is necessary, and only Mr.
Wait a
Soares.
minute, let's back that up. I mean, you say, I don't know what Mr. Long did. You know, I made a tactical decision not to know, not to find out.
No, I didn't say that, Judge.
You said you made a tactical decision not to talk to him. Because
Yes.
All right. Now you're saying, well, somebody says something on information and belief. Well, that's worthless. Well, how worthful is your affidavit if you're saying, by the way, I didn't talk to anybody? I'm just saying, look at the way this looks.
Okay. I'm going to ask a question that I believe, answer that, if I could, with, I believe, Judge Abdul and Judge DeFiore asked me, what facts did I provide? I provided an affidavit of Gary Wright. And he said, among other, I was sitting with him across the table at Woodbourne Correctional Facility on March 5, 2014. Yes, I prepared his affidavit, that's 80 through 83. But when I told him that Mr. Soares had been represented by Jim Long just a few months before Mr. Long came to represent him, his jaw dropped. Now, I was sitting across from him in a grim visiting room of Woodbourne Correctional Facility, and he was shocked. And even though he was wearing a jumpsuit, he had a right to be shocked. I mean, here he hires the attorney who thinks he's going to get a vigorous defense from that attorney, and lo and behold, the attorney 3.5 months ago just represented the district attorney?
Let me ask you this. If you had, because your red light is on, if you had, if you have a hearing, are you going to call Long? Are you going to call Long? Are you going to call the DA?
I thought about what would happen, and I think I would have to, and I also think what the result of that would be.
Thank you, Mr. Kasser. Counsel?
May it please the Court, I'm Chris Horn on behalf of the people of the State of New York. The allegation here is that there was an undisclosed actual conflict in the court below. It is the people's position that there was no actual conflict.
How do we know that? Why isn't he entitled to a hearing? I mean, it seems to me there are two people that would know that, Mr. Soares and Mr. Long. We don't have an affidavit from either one of them. And
it is, respectfully, it is his burden to establish those facts. I don't have any burden to prove or disprove his speculative.
Let's say, for example, Mr. Long represented Mr. Soares in his matrimonial. Those are sealed records. How would this defendant ever obtain that information? He makes a motion. He says, Judge, this is what I can show you. I can show you that Mr. Long represented the DA leading up to his representation of me and after his representation of me. I think that there's a fair inference that he represented him in between as well. And he makes a motion, and the only thing in opposition is an affidavit of an ADA who doesn't say on personal knowledge, doesn't even say I had a conversation with the DA. No, it just, based upon my review of the records in the DA's office, which of course I wouldn't expect there would be any if he represented him in a matrimonial, there was no simultaneous representation. How is that enough?
I am only required under the statute to deny. I am allowed to simply deny or not respond at all because I don't have a burden. He has a burden. He is speculating. Speculating is not enough. The statute is very clear on that. And if he does not come forward with sworn allegations supported by facts to make his papers legally sufficient, there's no reason why I should take a burden upon myself to disprove his speculation.
Counsel, let me ask you on that point then, if he had been representing the district attorney during this trial, would the office have had an obligation to disclose that?
There is an obligation on both sides if you're aware of a conflict or a possible conflict to come forward.
But your district attorney would certainly be aware of it, right? So I'm assuming
Sure.
if your district attorney is aware of it, your office is aware of it.
Yes, and when we were aware of it, we applied for a
So
special
can we
prosecutor.
assume then that because you didn't, you would have had an ethical obligation to disclose it? If you didn't, it would be a violation in this case.
It would be a violation. However, this Court has found that even when either side fails to meet their obligation of coming forward and letting the Court know that there's a potential conflict, that in and of itself is not enough to reverse or warrant a hearing People versus Abar specifically, the court said.
Where a district attorney is represented in another matter by the defense lawyer.
No, it was not the district attorney himself, but
Right.
but it was a conflict, and the conflict was not disclosed. And so the rules of professional conduct are not read into the Constitution so that is a so that you go through the constitutional analysis of whether or not you
But
received a fair trial.
would we
based on that.
agree that if there was simultaneous representation, it would be an ethical violation not to disclose it?
It would be in violation of the professional conduct rules.
Not only that, would it be an actual conflict that cannot be waived?
No, Your Honor, absolutely not. Actual conflicts, number one, can be waived unless, of course, the attorney is implicated in the crime that he's representing the defendant on in that case. That's per se reversible. But for an actual conflict to exist, you need three things, none of which are met here. There has to be concurrent representation. It has to be current representation of a key witness. Mr. Soares is not a witness in this case. He's not going to be testifying to anything. He's not a key witness. He's not a co-defendant. He's not a victim. So the duty that Mr. Long might have, and I would point the Court to People v. Solomon, the duty that Mr. Long would have to his defendant never comes into conflict with any duty he has with regard to Mr. Soares, because Mr. Soares is not on the stand. So it's not like he's...
Are you talking about disqualification of the DA, or are you talking about conflict of
I'm talking about actual conflicts as talked about in People v. Solomon. And that was the standard that was set forth. The first thing you have to consider is the nature of the conflict and the nature of the parties.
But couldn't you have a conflict here that he represents the DA, right? And something comes up in this trial where there's misconduct by the district attorney's office. Would not he have an incentive, since that's his client on another matter, not to raise that issue?
Well, that's not going to pertain to David Soares. I mean, that would be the DA's office. We're also sort of getting into the idea that he actually represented David Soares in that whole election thing. He represented the campaign, if at all, and it was just a letter
But
saying...
you can't draw that distinction. I mean, listen, there is a broader reality here, which is that, by my count, Mr. Long represented him on 5 different occasions, 5 different items. You know, divorce, a grievance, election law matter, an article about extramarital affair, and in every instance, the DA seemed to have used some sense and said in Long cases there's a conflict, I've got to recuse. And I'm assuming that they were more on spot, but certainly if there's not an actual conflict, isn't this enough for an inference?
No, I don't believe so, sir. Again, it's because you need concurrency. You have to prove the concurrency. There is no concurrency here. The election issue
How do we know that without, now you're sitting as a judge, how do you know that without a hearing?
Because the record is
Or are you
very
just
clear.
saying they just simply haven't met their burden for the hearing and that's it?
They haven't met their burden for the hearing, and ultimately, you got to look at the timing of everything. That letter was sent out in October of 2008. It was about the DA's name appearing on mail-in ballots.
Some of the
it was
things
just
that
a
struck-
letter.
Pardon me. What struck me in this is that you didn't. There was no response to to their 440, and a lot of the arguments you're making here might have been really good and very helpful, in that early stage. And you say, well, you don't have to respond, and I think that in certain circumstances that's true. But we do have motions to dismiss. We have things like that, none of which was done here, and so now all of a sudden, we're hearing from you, and we saw your brief and saying all of these things, but.
Well, I certainly did respond to the 440. Mm-hmm. I definitely did. And I denied that it was true. But again, the election law thing ended when the election ended. There were no issues there. It was one letter saying he left his name off, please put his name on. They put the name on. There was no litigation. There was nothing ongoing. It was over with. Then we're talking about the misconduct thing. The event that spurred the misconduct investigation didn't occur till a year after Mr. Long was fired.
But I think the inference that I think Judge Fahey was referring to is that it appears that in every instance in which we know that Mr. Soares consulted with or sought the assistance of an attorney in some manner or other, it appears to have been Mr. Long. So if there was something that we don't know about in between, it's likely that it was, again, Mr. Long. But if it's something that never became public, there would be no way for defendant to know that. So he shows the sequence of events, and he says there's an inference here, and that's his burden, and then he shifts the burden to you to say no, 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 and maybe there should be a hearing, but again, the opposition here is not with personal knowledge.
Correct, but it's also, he's relying entirely on speculation. I know we're calling it an inference.
What
but-
should he have done? What would he have had to do to
Well, the number
his
one thing
burden?
he should have done is gone to Mr. Long and asked for an affidavit. And there's plenty of case law out of the First Department that says if you don't go to that defense attorney and ask for an affidavit, summary denial lies. And he could have done that, and he chose not to do it for tactical reasons. I don't really understand why that would be a tactical reason, because you're then allowed to explain. If he doesn't cooperate, you're allowed to say, hey, I went to him for an affidavit. He didn't want to give me an affidavit. So there's your explanation, and now you've done your due diligence.
Would the attorney have breached any ethical violation by giving him an affidavit?
Not unless he was asking
what,
about
if any, relationship he had with the DA?
I don't think representing him is confidential. I mean, I don't think that violates anything, and it's certainly relevant to the case that's before the court. So no, I don't think that would have been anything.
He would have been able to answer his question, is what you're saying.
Yes, Your Honor.
Could answer your question too, correct?
Correct.
So why didn't you put in the affidavit? Only because you say it's his burden. I never had a burden.
That's what I'm relying on, and that's what I relied the whole way through, because there was literally nothing in that affidavit. He doesn't have any facts to say. I know it's being suggested that there's an inference, but there's not even an inference. There's no reference to other legal proceedings that he was ever involved with. We're just speculating that maybe that was the case, and maybe he hired Jim Long in that regard. That's not enough to sustain his burden in as far as I'm concerned.
Just as a theoretical, just as a theoretical matter, what if Mr. Long were unavailable, for example, he couldn't submit anything, even if counsel had gone to him and asked for an affidavit, he was dead or too ill or, now non-compos mentis, what would the...
I think, again, that's what you would put in as your explanation for why I did not come to the court with an affidavit, and I think that would be a valid explanation, but he did not go that far, and that was his burden to do.
Did he have to go to DA Soares? It's the other person who knows.
I haven't read anything that suggests that particular one, but certainly it would have showed more due diligence than what we have here, which is really just guessing and innuendo. It's not proof, which is what you're supposed to do. You have to have sufficient factual allegations to raise a question of fact, and he hasn't done it. And on top of it all, since I only have 1 minute left, even if you assume that there was a conflict here, there is no reason to send it back for a hearing. There is no reason to reverse, because the error was cured. His remedy here is to send it back for a new trial with an attorney who doesn't have any conflicts. His trial had an attorney with no conflicts. He was represented by Terry Kinlan at trial. So it would be redundant and meaningless to either send it back for a hearing or send it back for a trial, because he had counsel with no conflict.
Well, isn't part of the argument here about the pretrial motions and all of that,
You can't show anywhere in there where anything possibly could have operated in that regard. I mean, the whole speculation about loyalty to the DA because I represented him on some prior matter, that's been rejected in People versus Constantinides, People versus Abar. You can't just speculate about, some perceived loyalty to somebody, and that means you're going to tank a case.
Cases? Are those prior or concurrent representation cases you just cited?
Constantinides, the DA was accusing the defense attorney who was representing him on that trial of wrongdoing in the middle of the trial, of suborning perjury and bribing a witness. And People versus Abar, it was an ADA who indicted the defendant, left the DA's office, and then represented that same defendant.
So my point was that you said the trial would have cured that because it was a non-conflicted, but his argument is it was even before that it may have impacted on the pretrial proceedings, the omnibus motion, et cetera.
I don't see how it could be, again, because Soares is not a witness, he's not a victim, he's not a co-defendant. The alleged conflicts bore no relation whatsoever to the conduct of the defense.
I apologize. I was just trying to clear up the fact you say there's a trial, therefore no harm, no foul, and I'm saying he's saying there's a foul because of pretrial stuff, too.
He would still have to show some sort of operation on that, and I don't believe he can, particularly with the very favorable plea bargains he was able to procure for the defendant.
Thank you, sir.
Thank you.
Counsel?
Thank you,
Counsel,
Your
if there's no simultaneous representation here, what is the prejudicial effect of Mr. Long's representation of D.A. Soares before and after your client's case?
Okay,
Talk
for
me
the
through that.
reasons that Judge Stein expressed and also that the Court of Appeals previously has expressed is we don't know what other representation there was between these two
No, I'm
ends.
asking you, what is the prejudicial effect on the stage on the services that Mr. Long provided during the preliminary proceedings of his case to your client?
Well, among other things, he did no preparation, no investigation, and Mr. Kinlan stated that in an affidavit to the court. I think he said the file was bereft of any preparation.
He said that about Spargo, too, didn't he?
Judge, that's, I think he did both, and that's a factor which I didn't bring up initially, but Mr.
Work to negotiate a reduced plea resolution in the case?
Did he what?
Work to negotiate a plea
Well,
in the case?
two plea offers were made, and they were for, I believe, straight probation, and Mr. Wright rejected it. And Mr. Wright rejected it because he's innocent.
Did
And
Mr. Kinlan indicate that his effectiveness at trial was in any way hampered by anything that Mr. Long did or did not do?
Yes, I believe he did in his affidavit, yes. With respect to the plea, I've got to talk really quick. There's an exhibit, I think it's A68 or something, where after the plea was offered, Mr. Long said to the assistant district attorney, I'm going to work on the defendant to take the plea. That's in there in the DA file. Now, was that consistent with a defense attorney who's going to fight tooth and nail for his client?
Yes, yes, it is.
Maybe so.
A lot of times, that's the best advice that a
But this
defendant
is-
can get.
Yes, but it wasn't the advice that this client wanted to, he wanted a client.
But how'd
okay.
that work out for him? I mean,
Not well. But let me end by saying this, Judge. You brought it up, Judge Piggott, and it's been discussed by all of you. I did not make a haphazard decision not to speak to Mr. Long. It was we try cases all the time. We have to make decisions. Which sometimes have consequences which we don't anticipate. But I knew that the ultimate affidavit here to be from David Soares, not from Mr. Long. In any event, if I was at fault for not doing that, then if there's any way to take it out on me and not my client, I welcome that.
Well, I'm confused. Why do you say that the affidavit needed to come from Soares, from the DA Soares, not from Long?
Because he's the other side. Mr. Horn keeps saying it's just my burden. I disagree.
Because only the client can reveal whether or not Long was representing him concurrently?
No,
Is that what
I think they both could, but my position, Mr. Long isn't going to be a friend of mine, and Mr. Soares already had some conclusions reached by the Fourth Department about his conduct in judicial matters, so he certainly wasn't going to be a friend of mine or my client either.
Thank you, Mr. Kessler.
Thank you, Your Honor.
Thank you.